And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing fraud trust?
I'm saying that you are subject to the jurisdiction of this court.
This cannot move until you've proven jurisdiction, and you failed to do so. If you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter.
I don't know what it means because it's nonsense, but nonetheless. So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se. If you don't come back on July 1st.
Are you threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't show up.
You're threatening me now. What's the reason for the threats, Abigail? This matter needs to be
you back on July 1st. You're done. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
If anybody tries to touch me, I'll charge him with assault and battery. So I will be gone because this matter is dismissed.
Right out of the gate, this courtroom feels like a movie. We got a defendant invoking secret trust and accusing the judge of fraud, and the tension is off the charts.
Let's address. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to. I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
By doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I did
all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel. Well,
without my permission, he has no permission to be my counsel. I'm here sui juris, appropriate person. I, Jonathan Troy Colin Schuster, am here under fraud, menace, and duress. I've made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
Well, right now,
to answer them?
This is classic sovereign citizen rhetoric. The defendant believes the court has no power until it proves jurisdiction, but that's not how criminal courts work. Judges aren't obligated to prove their authority the way he's demanding.
Of what's going on, I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris in propria persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would.
Represent myself.
Well, you would. Either you have counsel or you are acting pro se.
I have told you, I'm here sui juris in propria persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an Admiralty maritime jurisdiction?
You can feel the judge's patience slipping. Notice how she keeps trying to get him to the microphone. That's not a power move. It's so the record is clear for appeals or future hearings.
Special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party and interest in military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Admiralty law, gold fringe flags, international contracts. These are internet myths. They have zero bearing on a state criminal court. But defendants who believe this stuff truly think they've found a loophole.
That you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
We cannot
that is
move
causing
forward.
you to not be able to.
To challenge my competency because I have challenged the jurisdiction of this court,
We're
and you have not
we're
proven
not dealing
jurisdiction.
in social security or contract
You
or
have to prove
maritime.
jurisdiction.
But that's just not how it works in this court, and
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I've challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you
I'm
prove
Judge Grant, so I'm going to
Jennifer,
have you,
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald. I don't know that this is him not understanding.
I do not understand the nature or cause.
Well,
of
he
this
doesn't have
matter.
he doesn't have legal training, so that I think is
That does
clear.
not matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move.
At this point, the prosecutor and judge are debating competency, not because he's mentally ill, but because his arguments are so off base they have to make sure he actually understands what's happening.
Sign the waiver of right to counsel.
absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I
We
understand
have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter. And I motion to dismiss this matter with prejudice
Denied.
based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven. To proven jurisdiction,
Jurisdiction is something that we prove at trial. It is a factual issue as well.
we cannot move any further until jurisdiction has been proven. And none of you.
Did the court say that was end of August, or?
It was August 9th is speedy trial.
So
And if you plan on having me back here, you're taking away from my ability to provide and work. And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom court available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right. So, Mr. Schuster,
You can also see how this delays the process. Every minute spent on fringe arguments is a minute away from actual defense strategy. That's why courts often appoint standby counsel, even when the defendant refuses.
Whatever you need to do to prove jurisdiction, but I know you can't. So if you want to waste more of everybody's time, go ahead, because obviously I'm not going to allow you to threaten me anymore, which you've done.
nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity, and that's ridiculous for what's going on here. That's absolutely ridiculous.
I don't think
This matter
anyone
needs
is
to be
told that they're
dismissed
being
with
put into
prejudice,
captivity.
and whether we need to take this to trial or whatever y'all need to do to prove jurisdiction. I mean, go ahead, but obviously you can't prove jurisdiction. So
I'm looking for the more
waste everybody's
detailed
time, please.
counsel
Waste everybody's time. It's absolutely ridiculous.
I don't know that he's done that yet.
No, he hasn't. I have a streamlined version, but I want him the formal.
The detail. We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel.
This moment hits hard. He frames court dates as a violation of his freedom to work. It's a revealing window into how he sees the system, but it doesn't change the fact he's facing real criminal charges.
And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines,
Ms.
and
Jennifer,
so your rights need to be
have-
protected.
Her-
This is for your
nobody-
benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my rights. And if you're gonna acquiesce, then okay, you're proving that you don't have any jurisdiction.
This is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel. If you,
I'm here of my own right and my property. You know what that
so
means.
there's the form.
I've
for you
never
to-
signed my power of attorney away to anybody, especially this.
You need to be respectful.
I-
You
I-
are really out of
I
line,
said
Mr.
this. I
Schuster.
didn't say anything disrespectful.
Listen to how often he says dismissed with prejudice. It's like a mantra. But judges don't grant that just because a defendant demands it. There has to be a legal basis. Clip 9. Now, the judge draws the line. She's been calm up to this point, but she calls him disrespectful and starts scheduling the trial. This is where the tone shifts from negotiation to consequences.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're gonna have to go through that because this case is gonna be going to trial. It's gonna be set on the August 6th, and that will be at 9 a.m. No, you're not free to leave yet, Mr. Schuster.
I'm not free to leave.
Not yet. No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be
Yeah,
dismissed.
it's not going to be dismissed right now. So
That's
right now it's getting
dismissed
set
with
for
prejudice. You can't
trial.
move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m.
don't
And
have
that
any-
hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you
Over
choose
and
not to
over.
come to your court hearings, a warrant will
Over
issue
and
for
over.
your
And you're
arrest.
threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yeah, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence. Let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening?
Petition back there?
We can set a pre-trial. Let's do it on the 22nd.
This is the inevitable crash of sovereign citizen ideology into reality. The court still sets dates, the trial still moves forward, and the defendant still faces jail time. It's a fascinating and frustrating look at how legal myths play out in real life.
Any contracts that I've entered into internationally,
Here's your court date. Could you
Uh,
please sign? for that?
especially if this is a Admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So
Mr. Schuster, you are in a criminal court and there are court rules. If you wish
criminal
to
matter,
have,
this is a criminal matter, you said?
Mr. Schuster,
That is a criminal matter?
if you wish to have discovery, then you need to abide by
You said
the
this is
rule.
a criminal matter?
Yes, and if you
Yes,
wish to have,
these are-
Oh, okay. I wasn't sure you said that. Thank you.
it's a criminal matter. If you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an Admiralty maritime jurisdiction?
No, we are not. Mr.
Are we under
Schuster.
a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery, then
Jurisdiction.
then you need to request,
Unless I give you my
Discovery.
permission to be under that jurisdiction, which I haven't.
you will need to request discovery from the prosecutor's office.
I'm not a U.S. citizen, American national. That's not a jurisdiction.
If you wish to have discovery, you need to request it in writing from the prosecutor's office and we will
You said your
send.
nationality was a U.S.
And then
citizen.
we,
Is that what you
and then
said
we will,
earlier?
and then we will send you the discovery,
Not nationality.
all of the evidence that we have
don't
against.
understand what's
Okay.
going on with this.
So-
This is ridiculous.
Here's my
Kangaroo
suggestion,
court.
Mr.
Absolutely.
Schuster.
Kangaroo
Mr.
court. And so since
Mr.
you guys are gonna waste everybody's time even more, goodbye.
Mr.
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 Schuster, you
Schuster.
need to sign for your court dates. I'm giving them to you orally.
Have a good day. Talofa.
If you don't appear for your court hearings that were given today, a warrant will issue.